Hi everybody, welcome back to 10 Minutes with Griffin. I'm your host, Griffin Bridgers. Today's episode is the second in a two-part episode titled Guardianship for Minors 101. So for this episode 145, we're going to continue a discussion we had yesterday on some of the issues and pitfalls that surround appointing a guardian for a minor. We're now going to dive into some of the specific how-tos as to the documents, mechanics, and other considerations that go into naming a guardian for minor children. Now, as always, this presentation is not intended to substitute for legal or tax advice and is provided for educational purposes only. So, today we walked through the issues behind doing nothing and teed up the fact that you need to take some affirmative action to name a guardian. So, today we're going to look specifically at how you do so. First off, in most states, you can simply appoint or nominate a guardian in your will. Recall we wrapped up yesterday's discussion looking at how some states are appointment states, where the court will in most cases respect your wishes as to the naming of a guardian, whereas other states are nomination states, where the court will take into account your designated guardian, but they're not necessarily bound by it. They'll still take into account the best interests of the child. But whether you're in an appointment or nomination state, typically the will is the most common way you can name a guardian. Now there's a couple problems with a will. Now first, especially as relates to online wills, you typically have to sign a will in front of 2 or 3 disinterested witnesses and a notary. And if the will is challenged or struck down or is otherwise technically deficient, that means the entire will could be invalidated, which would include your guardian nomination or appointment. So especially with online wills, form aside, one of the biggest issues with those tends to be that they're not executed correctly in terms of witnesses you name or notary you name or whatever the case might be. So that can create an issue to begin with. And then also, some states only will honor your guardian appointment if the guardian seeks appointment in a county where your will could have been probated. Now that creates an issue for out-of-state guardians because they can't necessarily take your will and then have it probated in the county that they live in. They're going to have to go get a certified copy of your will, and the county in which they live may not necessarily honor your wishes under that will. So they'll have to travel to your state and try to get appointed as guardians there and then transfer the guardianship proceeding to their own home state, which is a huge headache. And remember, the whole goal here is to have a seamless transition. We want to make this easy. So to shore that up, this is where you really need to check with an attorney in your state. And that's that some, but not all states, allow you to, instead of using your will, to name a guardian through a separate written document, typically that must only be notarized and not witnessed. And that could be an easier way to name a guardian and to change it. Now, once again, it's not a bulletproof solution. You could still have interstate conflicts of law, especially if you name a guardian in a state that doesn't recognize separate written instruments. But, as I mentioned, it's important to kind of take into account the laws in both places where the guardianship could be effective. But that being said, overall, the separate written instrument is a better way, not the best, but a better way to name a guardian. There is no best here. Now, beyond what happens at your death, it's also important to note that for temporary absences, like if you go on a trip and leave your children with their grandparents, for example, you could execute a temporary guardianship document, which is typically a power of attorney. And that wouldn't require court confirmation. Unlike with a guardian named in a will or separate writing, where the guardian has to accept appointment with the court, you could simply have this temporary power of attorney, which in most states has an effective time of 12 or fewer months. And what that would do is name whoever you're leaving your children with as a temporary guardian, and they could deal with school, deal with doctors, deal with health issues, anything like that that comes up. Now, this is a power of attorney, which means it's only effective during your life. So, doing this temporary written appointment won't necessarily replace the need to also have a will or other separate document that names a guardian who would take over upon your death. So now that we've looked at how exactly you name guardians and the essential documents to do so, it's important to note that when you're naming a guardian, the last guardian document controls. So you should make sure that if you change this over time, you make your changes known and accessible to the nominated guardians so that they can get the right forms and go to the right court to get their appointment or nomination confirmed. It's also important to note that most states give preference to a surviving biological or adoptive parent. So if you and the other parent aren't living together, or if you're separated, you can't use the guardian designation as an underhanded way to deny custody to your child's other parent. So with that being said, it's also, as a counterpoint, important to make sure that the other parent's wishes are consistent with your own in terms of the guardian appointment, because ultimately the guardian appointment of the last parent to die will control. But that being said, we've looked at death as a trigger, but incapacity or a doctor's determination of your inability to care for a child could even be the trigger for needing a guardianship for your children. So in that case, you should make sure your wishes are known that guardianship would be temporary and not permanent in whatever instrument you use to designate a guardian. And even though a will is only technically effective at your death, you could use a will in that certain circumstance to name a guardian as well. Now finally, if your own parents or family members or in-laws might get in the middle of this, if you're denying them guardianship and giving it to somebody else like a family friend, you should be aware that their voices could be given greater weight in a guardian nomination state. So with an attorney, you may want to walk through that type of potential dispute and look at what venue the guardian should seek to be appointed in, whether it's in your own home state or their own home state, whichever has the most favorable type of outcome. Now, from a financial perspective, this is a discussion that would almost warrant its own separate episode. But just to dispel rumors, it's important to call out that a guardian is not financially obligated to pay for the care of your child out of their own pocket. It's on you, in addition to naming a guardian, to come up with a way to fund this care until the child reaches the age of 18 and maybe even beyond. So with that, a lot of people cringe when they hear the term life insurance, but it's a great option to help fund this care. And if one spouse is not insurable, you could also consider a joint and survivor or second to die policy, especially because the financial need would kick in here if both parents are deceased. Now, with that being said, there's a lot of life insurance advisors out there who might try to sell you the wrong product here. So with this type of approach, term insurance is often okay. It may be a more cost-effective mechanism, especially if you're just focused on providing for the care of your children if both of you are deceased. So you should beware advisors who want to sell you a bloated permanent life insurance policy under the guise of fulfilling needs that you don't need or that don't relate to this objective of fitting in with guardianship. It's also important to note that some states recognize a separate role called a conservator. And we've discussed this in a prior episode, but a conservator is a separate role that manages the child's assets, whereas the guardian manages the actual care and living arrangement for the child. So you may have to have both a guardian and a conservator named in some states. So you need to consider whether you want your guardian to also be the conservator. And if not, if you don't want to mix the guardianship and financial roles, you should consider who would manage those funds for your children, and would it be better for those funds to be managed outside of court to forego the need for a conservator? In most cases, yes, it would be. And it's pretty easy to do so through a will or through other mechanisms in your estate plan that you can say that at your passing, separate trusts are created for each of your children, and those trusts could be the beneficiary of, say, life insurance, and that could help avoid that conservatorship need, and also name an outside trustee who can manage those funds, and maybe even make distributions to the guardian to help with the living expenses of your child. Now, this type of trust is actually extremely standardized in many attorneys' documents, both in wills and revocable trusts, and it shouldn't generate significant fees. This wouldn't be a huge upsell between a basic plan and just having testamentary trusts. That's what they're called, testamentary trusts set up for your children. And that is it on guardianship. I hope this gave you some value, especially in terms of action items that give a little bit more clarity as to what the process should entail to get into place an estate plan that accounts for this guardianship need. Now, as always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. Thank you for listening to 10 Minutes with Griffin, and I look forward to seeing you in the next episode.